From the roundtable at legendary Uncle Studios, welcome to another edition of WorkCom Matters, the central location for you employees, you employers, and of course, you independent contractors. My name is Steve Appel, and I'll be your host for the next hour with some talk, news, and hopefully some answers about WorkCom Matters. Thanks for being part of the show, and if you can break away from your WorkCom Matters, feel free to give us a call and clue us in. The phone number worldwide, 818-357-4120. Send me an email to wcexaminer@aol.com. You can send me an old school fax, 818-475-1437. With me in studio, my right-hand man, Mike Zima, family law attorney, Raymond Hekmat, my protege, attorney Robert Ozeron. Scott Walton of Uncle Studios is on the board. Special guest calling in, Lance Garrett of Garrett Law, and back at WorkCom Central, making sure the whole damn thing goes right, is Jake Paris. Well, good evening, everybody, and welcome to another edition of WorkCom Matters. We're talking about family law and divorce, but first we have a special news story. Lance Garrett from the Garrett Law Group is calling in, and I'm going to get him right now because he's got an update on West Valley MRI. Lance, take it away.
Good afternoon, Steve. Hope things are going well there at WorkCom Matters. This is indeed a subject that I believe was a subject of one of your segments a few weeks ago, and it is definitely a subject that does matter most severely to WorkCom. As you had reported several weeks ago, that there was a process being employed by a diagnostic imaging provider wherein injured workers were being presented with documents to sign that have a significantly different meaning than they've ever had in a workers' compensation applicant's case, whereby they would sign this document, receive diagnostic testing, but the proceeds would come out of their settlement. And what is known in other species of benefits as a lien against employee recovery. Well, as you reported a couple weeks ago, that diagnostic firm is involved in that, as well as it has spread to a couple other providers in the pain management field. Well, this past Saturday, there was a seminar unrelated to this subject in regards to medical reporting and litigation, post 863. And in the question and answer period, a couple of attorneys from the Valley brought a question up in regards to this situation with this West Valley diagnostic provider who was sending these signed documents to applicants' firms saying, we have a right to payment out of your client's recovery for a significant amount of money that is disproportional for the value of an MRI. Well, the question was directed at one of the speakers on the panel, which I was on, was Mr. Barry Hendon. And Mr. Hendon was aware of the phenomenon as it had been discussed briefly by various people attending the CON convention a couple weeks ago. But more recently, he had indicated that it had become a topic on the listserv that the Applicant Attorneys Association conducts, and that many attorneys had reported seeing this same out of the ordinary phenomenon. And so the response that he provided to the young lady was that it was a result of the efforts of a factoring organization who was entering into agreements with various medical providers for the purpose of funding their medical receivables. And he had made a statement to the 50 or so attendees that he was aware of it and had been in contact with this factoring organization, and had indicated to them that obviously it was receiving significant attention, negative attention, from applicant attorneys whose clients have been exposed to this alleged contractual agreement. His further statement was that in speaking with this organization, the funding organization, that he had let them know that it was probably an ill-advised of action.
And then sorry to interrupt. And was there a comment back from the factoring organization that they had made a business decision to no longer perform this type of practice of having the injured workers sign the document, the lien against compensation for future revenue? Is that correct?
He made the vague reference to the fact that they indicated that they would not be actively pursuing this course of action. But a very adroit attorney brought up the pointed question of, okay, presuming that is correct, what about all the existing documents that are out there now that contend to assert a contractual obligation to funds against a future recovery of an injured worker?
And was the answer essentially wait and see?
No, actually, he retold that their assertion was that it wasn't something to be concerned about. But I, as well as I'm sure other forward-thinking representatives, would be of the mindset that leaving that in place without any rescission of it would only expose a client to a possible negative outcome, whether in workers' compensation or in potential civil litigation. So the result of it's unknown at the present time. It's still a very fluid situation, but I believe it's one that now, because of the speed with which it spread, there are very, very disgruntled applicant attorneys in regards to the negative effect it could have on their injured worker.
All right. Well, listen, I want to thank you very much for the updated report. I hope you will continue to provide us updates as they come in, either on the telephone and or eventually we'll get you in the studio. Thanks a lot, buddy, and it's a pleasure for your contribution.
Glad to be of assistance, Steve. Be well.
You take care, my man. And
so they stopped?
Well, no. And firstly, that was Lance Garrett of the Garrett Law Group. Thank you very much. He was at like you said, a seminar on Saturday. One of the panel speakers was Barry Hinden. The issue was brought up by someone in the crowd, a San Fernando Valley attorney. Lance was there. Barry and the panel, although they knew about it, it was not on their list of things to talk about. But apparently the crowd wanted to talk about it. And this is what we got from it. Now, I know in my petition that I did for the July 2nd hearing, the judge looked at it and basically took Robert's point of view that the document is not worth the paper it's printed on.
Void ab initio.
That was my opinion back then?
Yes, my understanding was it was not a valid contract, void
ab initio.
And that,
I guess I got lucky, huh?
Well, I personally disagree with you and the judge. I say that the contract is valid until it is adjudicated, and a judge says it's not.
A judge just said it's, well, not adjudicated, but yeah, a judge just gave you his informal opinion.
I asked, what I did was I filed a motion, and the judge denied my motion, but there was nothing on the record that said the contract was not valid. That has to be adjudicated or dealt with at a later date. And so I don't know how many of these contracts are out there, but in my opinion, they are going to have to be dealt with one way or the other, either under the jurisdiction of the Workers' Compensation Appeals Board or in small claims court. But we will certainly find out.
I don't think it'll go to small claims either. Well, perhaps small claims, but firstly, anytime that there's a attempted debt collection, which what this theoretically would turn into if you're saying they're personally liable, which, of course, I disagree with entirely from the start, that would be a different issue. Then you would send there's like a fair debt collection practices. We talked about that. And you can send your objection letter, and they can't just ding your credit. They actually have to sue you. if they want to collect on any type of outstanding bill. But I believe you have to have a legitimate dispute. In this case, it would be one.
Steve, did I understand that Lance said that it's his understanding that this entity has stopped this practice?
That was the inference, but there was nothing in writing, and I do not believe it came from the horse's mouth. It came from like Barry Hinden or someone on the panel that they had a discussion with the factorer, the proprietor, the person responsible, and this is what they said they were going to do. But if you put out 100 or 200 or 500 of these contracts, they're each worth a couple of grand. No one's throwing away hundreds of thousands of dollars in receivables without at least attempting to collect something. I mean, that to me...
Well, they're going to attempt to collect. They're going to need to file their lien. The problem, of course, is the lien system in workers' comp. This is really what I
They
talked
say
about
it's not
before.
a lien, though.
Well, of course,
That's
but this
the
is
point.
but this is the issue that's really that's the problem, is that the liens have been perhaps overly attacked by the legislature and the insurance companies who lobby them, and because of that, now these lien providers are desperate to try to figure out a way to collect on their bills. So that's what I told you guys at the outset, is it's more of a sign of desperation in the current status of things than it is an actually collectible type of transaction. I just don't see them being able to collect.
Well, we
have a lot of reasons why.
We're going to find out, and I didn't want to turn the whole show in regards to West Valley MRI, but that's the up-to-the-date information regarding it, and we will get updates for it as information comes in. My name is Steve Appel. You're listening to Work Comp Matters. We're brought to you by A1 Law Santa Monica Tickets and ABC Rugs. If you want those hard-to-get, sold-out, even front-row concert, sports, theater tickets, give our buddy Brian a call at Santa Monica Tickets, 310-395-8587. Of course, I'm the rep from A1 Law, the #1 computer management system used by more workers' compensation attorneys than any other system in the Kuiper Belt. Give me a call at 818-357-4120 for your no-strings-attached, money-back guarantee, $1 a day, A1 Law. And our newest sponsor is ABC Rugs. How was that pronounced, Mike?
We did look it up. Keeling?
Keelings. I'm just going to go ABC Rugs. They've been in business as a manufacturer and a direct importer and exporter of Persian and Oriental rugs, machine-made, shaggy, and hard-loomed rugs for more than about 50 years now. They have the largest selection, and it's ABC Rugs at www.abcrugskillums.com. Give them a call at 323-897-5454. We're going to get to my guest in just a moment. We've got news stories coming up regarding Donald Trump, Dr. Ronald Grusid, the MGM Grand Hotel, population and memory of dreams. The Ford Motor Company is in the news. The United States government is investigating Uber. City of Ventura is opening full-service year-round shelter for the homeless. San Francisco voters are going to decide whether to put hundreds of millions of dollars to help the homeless. We have a story on California assault weapons. We have a class action potential suit with the NHL, the Hockey League, and some other information about self-driving cars. But I wanted to talk about two things first. The first thing, I was talking on last week's show about the Los Angeles Times and the Los Angeles WCAB and a rumor that they were there to do a hack job on the Los Angeles WCAB. Now, I don't know if this is related or not, but on the first page of this past Sunday's Los Angeles Times was a story about workers' compensation and about police and or firemen and about the continuous trauma injury. And I encourage any of you that either get the LA Times or can access the LA Times to read this story about firefighters and or policemen and continuous trauma injury. So that's number one. Number two, we have a story. The California Governor Jerry Brown recently appointed former chorus director Juan Pedro Gaffney to the Workers' Compensation Appeals Board Commission. Now, The commissioners have 7 seats. I think all of this year, only 4 of them have been filled. 5 of these 7 seats, if I'm not mistaken, one of the requirements is you have to have graduated law school and pass the California bar. You might even have to be a workers' compensation specialist. However, 2 of the seats apparently have no requirements at all. Jerry Brown appointed an 80-year-old man that he went to high school with, who, from what I can tell, has no experience whatsoever in workers' compensation. Now, this requires California Senate approval, but I think the job pays over $147,000 a year before any stipends, travel fees, whatever the case may be. I am mad. I am fuming. There's steam coming out of my ears, and I'm going to tell you why. Jerry, if you wanted to appoint a non-attorney with no experience who would just sign off, you got the right guy. However, if you wanted to appoint a non-attorney with someone that has a lot of experience in workers' comp, arguably an expert in workers' comp, someone who's been living, breathing, eating it for over 25 years, here I am. Let me tell you, I will divest all of my interest in Appel and Associates. I'd like to keep the show here going on. You know, I will divest in all of the applicant firms that I manage. I will get out of the day-to-day grind of workers' compensation. I will go get an apartment in Sacramento, and I would absolutely love to be a WCAB commissioner.
But have you ever been a choral?
A chorus.
A chorus leader?
I can't. I am tone deaf when it comes to my voice, but I can play some piano and guitar, but not that good, and that's why it's never been on the show here. But if you ask me to sing, forget it. But get back to the point. I would love to be a WCAB commissioner, and I don't know if it's a lifetime appointment, but I would take it absolutely seriously. I understand the job. I would do my best to get along with all the other commissioners, and for me, it would be a lifetime dream come true. So I am going to go ahead and take a very rare negative position and say, for you, I believe there are 40 senators and 80 assemblymen, I vote no on this person for WCAB commissioner, and I think instead they should bring Steve Appel up there to talk to the Senate. I was born and raised in Southern California. I have not even been arrested in over 35 to 37 years.
No recent arrest is good.
No recent arrest. The last time I had a car accident when my wheels were moving was over 25 years ago. My taxes are paid up. I have no arrears for alimony or child support. My kids are more than 18 years old, and let me tell you something. I am like red, white, and blue. And of course, I'm a rhino. I've admitted it. I'm a Republican in name only, but like Robert, I do my best to decide based on the issues and not on the political leanings. So if any of you are interested in having a non-attorney as a WCAB commissioner who knows about workers' comp, it's me. Now, that being said, it's time to get to our guest. I've kept him waiting long enough. My guest was born and raised in Southern California. He graduated from Robert's alma mater, Beverly Hills High School. He then got his undergraduate degree of University of California at Irvine and got his law degree from Loyola Law School. For the past 9 years, he has devoted his practice and his career exclusively to family law, including, but not limited to, divorce, paternity, custody, support, as well as prenuptial agreements. He is a member of the Los Angeles County and Beverly Hills Bar Associations, and it is my pleasure and my privilege to welcome to Work Comp Matters attorney Raymond Hekmat.
Thank you for having me here.
The pleasure is mine. How do you like legendary Uncle Studios?
Beautiful place.
Don't you know? We can just stretch out and kick back and relax. Now, what I didn't say in the intro is you also work on mediation as well. And in fact, I believe you stress that as an important part of your practice.
Yeah, so a large part of my practice is based in family law mediation and divorce consulting. So what I do is I help my clients. I help my clients through their own mediation process with a separate mediator, and I also consult them during that process. So a lot of times I may help them strategize and work through the mediation process and help them come to amicable settlements through the mediators.
What are some of the things that people that are common issues for people who want to have an amicable divorce?
Well, I mean, there's all kinds of issues in family law that can come up and people need to work through, whether it be child support, custody,
I'm thinking
property
I'm
division,
thinking alimony is number
spousal
one.
support. Well, alimony is a big issue right now because of the new tax plan that's coming into effect in 2019. Because spousal support is no longer going to be deductible for the payor, and it's not going to be It's not going to be taxable income for the recipient. So that's going to have major effects on how settlements are going to occur throughout this year. I think now it's a little too late.
Now, it's no longer deductible, but is it considered income? Do you have to declare
No.
it as income? Oh, okay. So you don't have to declare it as
Yeah,
income.
so you're not going to declare it as income. Well, yeah, it's not going to be taxable as income. So it's going to kind of fall under the same category as child support, where it's after-tax money and it's not taxable. So the numbers are going to be very different than what we're dealing with right now.
You know, I heard a news thing a couple of weeks ago that Kevin Federline, who is Brittany's ex or baby father or whatever,
yeah.
they had an agreement to $20,000 a month, and
Right.
apparently he's going in to ask for more money.
Well, she's earning a lot more money now through her Vegas shows, so...
So that would be a change of circumstance.
Absolutely.
So regardless, even though they were only married for a couple of years and they've been divorced or separated legally for many years, she's making more money now, so he can go in under a change of circumstance.
Yeah, child support, length of marriage has no effect on child support. The reason for child support is so the children continue to have the lifestyle when they are with her, and at the same time that we are there with him. So the idea is that they shouldn't live two different lifestyles in two different homes.
Now, you said it doesn't affect child support, but length of marriage does affect alimony, because
It does.
I know there is a 10-year presumption of lifetime alimony. Is that correct?
I wouldn't call it a presumption, and it's not necessarily lifetime in every way, but yes, there's a 10-year rule. So
Did that change recently, or
no.
is it's the same it's always been?
It's the same it's always been. So marriages of 10 years or less, generally the spousal support payments are going to be ordered for half the length of marriage.
Half the length of the marriage, right?
And anything 10 years or more is until remarriage, death, or further order of court. Obviously, sometimes there is a court can make a Gavron warning, which tells the payee that they have a duty to become self-supporting and they need to go out and get a job. Whether that holds any water, it just makes everyone really feel better. It doesn't make a difference, but...
Now, it's called spousal support now. Alimony is no longer a term in family court.
I was going to ask that. Are there synonyms?
It's the same thing.
They're
It's
the same
synonymous.
thing.
Yeah.
We don't call it alimony in the court system, and we don't call it alimony. It's spousal support. I don't really know when or how it changed or why one term over the other, but yeah, we call it spousal support, but it's the same thing.
Now, let's say hypothetically I go into a marriage and I own $1 million house,
Yes.
and there's $500,000 in equity, and I get married.
Yes.
And then I'm married for 5 years, and the house appreciates from $1 million, let's say, to $1.2 million, and then we file for divorce. My ex-wife would be entitled to arguably half of the $200,000 appreciation and nothing else. Is that correct?
No, she would be entitled to at least half of the appreciation plus a reimbursement of community funds that were used to pay down your separate property asset. And the way it's calculated is using a equation called a Moore-Marsden calculation.
Moore-Marsden.
The Moore-Marsden are two cases that they kind of grouped together, but came up with this equation that our forensic accountants can use, and it factors in appreciation plus reimbursement of half of community funds that were used to pay down a separate property asset. So she would be entitled to half of that money back that has basically improved or bettered your investment.
Now, in workers' compensation, we have a permanent disability and a temporary disability scheduled. It's run by the state. In family law, we have what's known as the dissomaster. Now, tell me where the dissomaster started. Tell me what info you plug into it, and tell me if it's only advisory, if it has to be followed, or when can it not be followed?
Well, define it first, if you will.
So
please.
the Dissomaster is a computer program. I don't know how or when it was started or when it was adopted by the courts, but the Dissomaster is a program that family law attorneys use to calculate spousal and child
And
support.
the judge uses it too.
The judges use it for both as well. The way it's used is more so to calculate guideline child support, and that's what the court will use for purposes of ordering child support. In the realm of spousal support, it's used to make orders of temporary spousal support, but it's not supposed to be used for permanent spousal support.
Really? I didn't know
Right.
that.
So it's not supposed to be used for permanent spousal support. However, family law attorneys use the Dissomaster to help and facilitate settlement
As a guideline.
Well, it's a guideline, but there's also something called the B key that family law attorneys use, and it's literally pressing the B key on the computer, and that gives you a better idea of what permanent support would be. Permanent support is usually a much lower number than the temporary spousal support number, and there's a lot of different factors and equations that just get all mixed up within this Dissomaster program. Don't ask me to explain how it works, but most family law attorneys don't know how it works. We just use it every single day, and it's kind of a scary thing, but it's basically a lot of times it's garbage in, garbage out. We plug in people what they believe is their income or what their W-2 shows. You put in factors of interest payments, different dividend income, all kinds of income, the number of children you have, the percentage of time that you have with children, whether you file single or head of household or whatever it might be. You put in your tax deductions, deductible payments that you're making, health insurance, child support add-ons, things like that, and then it busts out a number at the end.
Basically, all of the money that you make, all of the expenses that you pay out, it's put into the program, and the Dissomaster spits out something.
Right.
I've got so many more questions I want to ask you, and I'm going to, but we have to take a break for some news. I want to do like one or two news stories. We'll take a musical break, and then we're going to come back and talk with attorney Raymond Hekmat about divorce and family law. He's my right-hand man. He keeps me in check and out of trouble at least 90% of the time. With the first news story of the night, he's the chief of staff, Dr. Michael Zima.
Thank you, Steve. President Donald Trump insisted on Wednesday his meeting with Vladimir Putin was a success, despite condemnation from lawmakers of both parties who expressed dismay over his failure to confront the Russian president about Moscow's meddling in the 2016 election. Some people hate the fact that I got along well with President Putin of Russia. Trump also tweeted they would rather go to war than see this. It's called Trump derangement syndrome.
Dr. Gusht was sentenced to 10 years in federal prison for a healthcare fraud scheme. Apparently, Dr. Gusht would bribe other physicians to refer patients to him and then bill insurers. It looks like for $100,000 in bribes, he referred over $22 million in business. Not bad return on investment if you don't count the 10-year prison sentence.
MGM Resorts International is suing over 1,000 victims of a Las Vegas music festival mass shooting in an effort to prevent them from paying any compensation to the victims.
And we have a lot more news stories, more talk, and hopefully some answers on work comp matters. My name is Steve Appel. My special guest is attorney Raymond Hekmat, a family law extraordinaire. We're brought to you by A1 Law. If you want the #1 computer management system used by more workers' compensation attorneys than any other system in the damn Kuiper Belt, give me a call at 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day. A1 Law. If you want those hard-to-get, sold-out, even front-row concert, sports, theater tickets, give my buddy Brian a call at Santa Monica Tickets, 310-395-8587. And, of course, our newest sponsor is ABC Rugs. They have been in business for over 40 years. They sell wholesale and to the public. And if you want the best Persian and Oriental rugs, give ABC Rugs a call at 323-897-5444. We'll be back after our musical break.
How does it feel to be one of the beautiful people? Now that you know who you are, what do you want to be? And have you traveled very far? Far as the eye can see. Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do. How does it feel to be one of the beautiful people? How often have you been there? Often enough to know. What did you see when you were there? Nothing that doesn't show. Baby, you're a rich man. Baby, you're a rich man too. You keep all your money in a big brown bag inside a zoo. What a thing to do.
La Familia, Glenn Laughlin of the Cherry Blue Storms on Work Comp Matters. My name is Steve Appel. We're brought to you by A1 Law. If you want the #1 computer management system used by more California workers' compensation attorneys than any other system on the planet, you give me a call. 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day. A1 Law. And if you want those hard-to-get, sold-out, even front row concert, sports, and theater tickets, give my buddy Brian a call at Santa Monica Tickets, 310-395-8587. And our newest sponsor, ABC Rugs. They've been in business for 40 years. Manufacturers, wholesale, and retail for Persian and Oriental rugs. That's ABC Rugs, 323-897-5444. My special guest is family law attorney Raymond Hekmat, and I've got so many questions for you. I forgot to give my disclosure. I was married for 11 and a half years. I was separated and divorced back 17 years ago. I have not remarried since. I'm doing my best to keep my personal bias out of the show, and I think so far I've been pretty damn successful. And so we're going to continue on. We were talking about income. Talk about hiding income. I see more hiding income in family law than any other aspect of law. What's your take on that? Well,
of course. I mean, people want to hide their income because that's the only way that we can determine support as well as division of personal property. And we work very closely with forensic accountants that we trust to find where that hidden income may be. And a lot of times if somebody's running their own business, the hidden income can be in personal expenses being run through the business. Many times we have cash under the table with people working with family members where they might be earning a $20,000 salary on paper, but they're getting paid a couple $100,000 cash otherwise, or maybe expenses are being paid on their behalf by third parties. There's a lot of ways we can find that extra income, and it all comes from the expenses, reviewing expenses and seeing what quality of life a person is living, and if they can actually be living that lifestyle with the income they're saying they're making.
Now, everybody that listens to the show or knows me knows I'm a huge fan of cliches, and one cliche I always use on the show is follow the money. If someone comes to you and either hasn't filed for divorce or they just got hit with a divorce notice, do you advise them as one of the first initial things, go get the money, transfer it out of the joint account separately? What do you advise them regarding the money?
So...
Well,
you put me in a little bit of uncomfortable position because I can't.
It's not against the law.
If I could
Right,
jump in,
so-
I think maybe his
Robert.
personal advice off would be different than the formal advice he's
Right.
supposed
Well,
to give.
let's try this.
So I'll tell you,
Is it against the law?
it depends.
Okay.
Right, like any other attorney answer, it depends.
If they're looking to
If somebody has been served with a petition or they've been served with the formal summons, there's something goes into effect called automatic temporary restraining orders, and at that point, there are actual financial restraining orders placed on an individual that don't allow them to be moving money around. So in fact, if they do so, they could be found in contempt of court.
Let's say that I plan on getting married later this year. And
Congratulations, Bob.
Thank you. And then I get married.
Yes.
And then it's not working out next year. I haven't filed yet. And now I come to you and I say, I'm thinking of filing for divorce.
Yeah.
What should I do with the money in the joint account?
I think what you need to do, what I would advise some of my clients is that you need to keep track of your money. You need to know where all of your money is. Print out those bank statements. I can't advise anyone to actually withdraw money or move money around, simply for the fact that you don't know where you're going to be 3 months from now. You might be in front of a judge, and it may reflect poorly on you, on your actions and what your intentions were and what you're trying to hide from your spouse. So as family law attorneys, we like to keep things as status quo, so everything's in the same place so that it doesn't complicate issues. It can only increase fees and increase complications moving forward.
I got a question here.
Yeah.
What's the biggest case you worked on? Like the biggest pie you split, so to speak?
I mean, they go up to a few $1 million. I mean, we're talking about $10 to $30 million estates. I deal with the prenups that I deal with are generally in that range, about $30 to $50 million estates, and they're people that are looking to protect assets and they're real estate developers. But some of the estates that I deal with are close to nothing. A lot of people that I deal with on a regular basis are short-term marriages that may not have the assets, and I work with them on a flat rate basis. So I help all different kinds of clients.
I bet you have a lot of stories about how individuals have acted in certain respects.
More than you could
cocktail
possibly
table.
understand.
I can only imagine what type of stories.
Speaking of that, what
We should get a story before we're out of here.
and absolutely, what my attorney, he'll be anonymous, what he told me a long time ago when he was representing me was the difference between family law and criminal law. In criminal law, you have really bad people going into court looking good, and in family law, you have really good people going into court bad.
Right. And unfortunately, that's when you start the litigation, and if you're going to start off on the wrong foot, it's only going to get worse.
Is it true that generally speaking, a good marriage will be an easier divorce, whereas a very bad contentious marriage is a very bad contentious divorce?
Well, of
Is that
course,
true?
I personally believe so, because I think the foundation of a good marriage is communication and proper communication. So even if two people are not getting along or they feel like they are probably better off divorced, that communication still continues post marriage. And if two people are able to continue communicating and they're able to talk about what they think they are either entitled to or what they need, more importantly, and have an understanding of someone else's position, then they can come to an amicable settlement. But if there's not that, there's no communication, there's a dishonesty, there's a mistrust, that's when things get escalated, and then we're heading to litigation.
Here's my last cliche. Is it true that the reason why divorce costs so much is because it's worth it?
It's worth it.
Yeah, that's a very good point. You mentioned prenuptial agreements. What percentage of marriages these days come with prenuptial agreements? I'm thinking extremely small, like less than 1% or something.
So, I mean, I don't have absolute percentages, but it is very small. A few number of the divorces that actually come into my office have prenuptial agreements that we're dealing with, unfortunately. However, I have seen a rise in people getting prenuptial agreements these days, both because people are getting married later in age, people are getting married second and third times, and there's also a lot more family money, there's inheritance, there's a lot of factors where people want to protect assets, and we also have a lot of households with dual income, and people have established their careers, and they look at their marriage as a partnership, and they want a document to help them as a blueprint for their marriage.
Have you ever seen an engagement blow up because of a postnuptial agreement?
Sure. They can blow up because of a prenuptial agreement, but it's not because of the prenuptial agreement. It's because of the financial conversations that people are forced to have prior to marriage that they maybe weren't ready for.
Well, they probably should have had those conversations anyways,
and
right?
That's the point. I mean, what I always tell my clients and people that are coming to me as I do premarital financial consulting as well, where somebody is thinking about getting married and they want to know what California law, how it's going to impact their finances and through their marriage. And we talk about, hey, have you had these conversations with your fiance? And the answer is almost always no. I haven't told her how much I make. I haven't told her what my assets are. We haven't talked about what expectations are going to be.
Well, guys can get gun shy, you know.
Yeah, but the problem is that people think that getting married is just all about love, and if we love each other, everything is going to be okay. Unfortunately, it's not like that. I mean, marriages require really uncomfortable discussions and conversations every single day.
And statistics bear out that marriages fail more often than they succeed. And correct me if I'm wrong. If you get married in California and you are under 25 years old, that marriage is going to fail 80% of the time within the first 10 years. If you get married anywhere in the United States at any age, the average divorce rate within 10 years is 50%, correct?
Well, I'll take you on that. I
Okay.
don't know the exact numbers, but that sounds about right. And we do have a lot of people that are also getting married very young and not getting into serious committed relationships and thinking that, oh, it's just time for us to get married, let's just get married, without, again, having those necessary conversations to build the foundation of a successful marriage. And that's what prenuptial agreements can help with.
I know Robert wants to ask a question.
Sure.
In speaking of that, what about postnuptial agreements? Are you doing more of those lately?
I wouldn't say I'm doing more of those, but I do a good amount. There's a lot of people that maybe it's an addendum to their prenuptial agreement, or they want a confirmation of separate property. Maybe they've inherited something and they just want to make sure that it remains separate property, even though they're putting time, skill, and effort into managing the property. But there's some circumstances of that, and there's also, I've done a lot of cohabitation agreements as well, and that comes into play these days, where for people that don't want to get married and don't believe in the institution of marriage, but they want to live with their partner and not open themselves up to Marvin actions.
Common law marriage.
So in
Palimony, right?
Well, in California, we don't have common law marriage, but we have case law that provides that if someone has made certain promises and there's been sacrifices.
That's Lee Marvin from the 60s, right?
Yes.
Yeah.
That's palimony, right? That's what
Yeah.
they call it commonly now.
Right.
Robert, you had a question.
Well, I was just wondering if you could give advice as to the biggest thing you would give somebody like me, maybe a few years younger, perhaps entering the marriage world soon, maybe. Who knows? But what would be the one thing you would give advice? The overarching thing? Pretty much just don't avoid the problem,
Don't
confront it,
do
and come
it.
to you? Well, here we go. There's Steve's bias there.
Well, I mean,
But you know what? Maybe if you went to Raymond ahead of time, huh?
Right.
You would have been a little bit more secure with that divorce.
I
there.
think the number one. I mean, look. What I have always advised my clients. I want people to enter into successful marriages. That is never my goal. And that's why I want people to come to me for prenuptial agreements. I want people to come to me for that premarital financial consulting, because I think it's so important to have those conversations before you get married. And I see so many people coming to me, young people, young marriages coming into me 3-4 years later saying, I don't know how much he makes. I don't know where our money is. I don't know what we're doing. He says he's a doctor, but we've been living in an apartment in Beverly Hills, and I don't know where the money is. So it's about those conversations. And my advice to that person or to you would be, have the conversations. Talk about your expectations of money. Talk about how you guys are going to build together. Where is the money going to go? Who's going to contribute where? It's just really important to have those conversations and not avoid it. Don't avoid the red flags, and don't avoid the conversations.
Speaking of that, what are the red flags?
Oh, geez, we're going to get into the red flags of relationships right now?
He brought it up.
Sure,
I
go
mean,
for it.
I mean, somebody that doesn't want to talk about it, right? So if somebody says, hey, let's sit down and talk about our finances. We're in a serious relationship. How do you foresee our money being spent, or where do you see it going?
You making me spending.
If the answer is, don't worry about it, I'll take care of you, there's nothing you'll ever need to worry about. And I personally think that's a red flag. Some people may not think it's a red flag. If somebody just says, like, if you start, you're living in this house, who owns this house? He's like, oh, I don't want to talk about it. Or, you know what, it's my mom's brother's cousin, and my uncle pays the mortgage.
Well, we've referred to that on this show as brutally honest. I mean, certainly, in my opinion, if you're going to get married, you and your spouse have to be brutally honest.
It's a partnership, after all.
Actually,
it's an open partnership. You have to be totally open.
It's a business. You should be totally open and honest. And I agree with you. If one spouse is asking the other questions, the other, don't worry, I'll take care about it. You don't need to know. Those are red flags.
Absolutely. And I think that's the beautiful part of a prenuptial agreement, is that it forces full financial disclosures. It forces people to have that conversation, and it's not necessarily a document that's going to dictate what happens in your divorce. How I draft my prenuptial agreements with my clients is a blueprint for your marriage. It's about coming up with those terms and provisions on how we are going to grow together within certain guidelines, and how we are going to structure our finances as a family. And people say, but prenuptial agreements aren't romantic. I don't want to do that. It's an uncomfortable discussion. And I tell them, well, you know what?
Paying bills ain't romantic either, baby.
Yeah, whether you like it or not, when you get married, there's a prenuptial agreement. It's called California law. California law is your prenuptial agreement, whether you like it or not, right?
You don't have a private, it's like dying intestate. If
exactly.
you don't have a will,
it go to probate.
Exactly.
So what I tell my clients is, well, look, you have certain circumstances, and California law may or may not apply to your specific circumstances. This is your opportunity, and it's actually one of the very few opportunities in our state where you can create your own law to oversee your marriage, as long as it doesn't go against public policy. And it's a really cool thing to do, to really come up on how are we going to work together to build the laws dictating our family unit. And I think it's a great conversation to have, and I think it's a fun conversation to have, because you're thinking about the future together. You're thinking about how things are going to be worked on during your marriage, and there's not going to be any surprises. There's going to be very open discussion of, look, I have this building. I received this building from my parents. This building is going to stay a family asset, but the income is going to come to both of us, or 50% of the income is going to come to both of us, and half of it is going to go to the side, and those conversations keep occurring.
I have these 3 mistresses that I've been seeing since before I met you, and I want to keep seeing them.
Well, that's my question there, boss, is how many of these prenups have contingencies like infidelity?
So infidelity clauses are against public policy, and they are unenforceable.
I was about to get into the TV show where you're following them with a video camera.
And so many people have heard these stories.
I was going to get into Melania and Donald's prenup,
Well, I think a lot of people hear these stories of infidelity clauses, and all of these movie stars that have infidelity clauses
TV
in
show
their prenups.
cheaters, right?
Yeah.
Actually, I think it's basically called the "Don't Embarrass Me" clause. As long as the whole world doesn't find out and you don't embarrass me, it's okay.
But why is infidelity against public policy? You think that would be something that the public policy would want to encourage?
Because we live in a no-fault state, so you can't penalize
workers'
somebody.
Comp? It's a marriage, after all. Trust me, if you're cheating on someone, there's fault, okay?
So we're in a no-fault state, so the idea is that you're not allowed to penalize anyone for infidelity. So that's why it would remain to be unenforceable. I've seen a couple with those clauses in them, and they rarely are upheld. I don't really know any circumstances where they would be, but
I can imagine that the aggrieved spouse is really pissed.
oh yeah, of course.
Because
and I've had a few cases where somebody wants to bring it up as a postnuptial agreement, that somebody has cheated, and they want to say, okay, either I stay with you and you sign this postnup giving me everything, or I'm going to divorce, or not, or we stayed married, or I'm going to divorce you right now and take half of your money. And the postnup is supposed to include an infidelity clause that you'll never do it again.
You know, we were talking off mic about the overweight clause. Now, I know that at least in workers' compensation employment, it's not against the law to fire somebody because they put on pounds. That's not one of the Title IXs, correct? You can fire someone for being...
Well, unless it's related to a genetic or
right.
medical condition.
If you are an employee if you are an employee at Hooters,
gluttony is not one of the protected
classes. You can be required to have to fit the suit, or else you can be fired. Tell us about the overweight clause potential.
So I have seen instances where an annual. So as part of a prenuptial agreement, sometimes we have an annual gift that one person will pay the other in lieu of consideration for giving up rights on property and future spousal support. But sometimes those annual gifts have certain contingencies or milestones that need to be met. And sometimes they're weight restrictions.
It's like making the football team. You don't want to miss a season.
So you're only entitled to that annual gift if you meet a certain restriction.
And that's enforceable?
I haven't seen it. I don't know in terms of court. I haven't seen it tested. A lot of those things end up being settled out of court because most of the rest of the prenup is going to be enforceable. So it's about really, again, what's happening during the marriage and a conversation as to whether or not they're entitled to that money or should have been entitled.
Are there any other any other strange conditions that can find their way into prenups? And
I would say anything that the two people agree on.
Yeah, anything that two people agree on, as long as it doesn't go against public policy and it doesn't seem like someone is getting paid for any sexual acts. Aside from that, it's all fair game. Whatever is good for you and your partner and your marriage and what the two of you agree on and you believe is
leather straps and handcuffs, but just no money exchange. That's right.
What about if one spouse wanted the other to walk the dog at least every other day?
I mean, look.
Could you throw that in there? Both sides agreed?
Absolutely. You can throw that in there. I mean, there's going to be enforceability problems. And I always tell my clients, you can include something in a prenup that's going to occur during your marriage, but what's going to happen? Something like that. Your husband doesn't walk the dog that morning. You're going to take your husband to court. What are you going to do?
Yeah, that's a good point. I saved what I think is the most important question for last because it's been in the news constantly. What's going on lately with child support services, Department of Family Services, where you have these kids that are being killed by the mother and the girlfriend, and Department of Family Services has gone out like 85. There's been 85 reports, and they haven't taken the kids away.
The Antelope Valley is the most recent example.
Can you add any comments to that?
Unfortunately, I haven't heard about that story, but I don't deal with DCFS or those government systems at all because I've seen them to be so ineffective and I've seen them really put families in danger many times.
Well, there's a response. They've been ineffective,
and they really do slow down the process, and it a lot of times it takes. It doesn't allow the judges in the family law court to do their job.
They slows down what process? Well, custody?
Custody proceedings, child support proceedings, family law proceedings. Because if there's a DCFS case open or if Department of Child Support Services has opened up a case, the family law court doesn't have jurisdiction anymore.
Do you go with the special master often on custody issues?
Well, again, everything would be deferred to DCFS, and everything is deferred to the government program. The court no longer has jurisdiction, and their hands are tied. And now you're sitting around waiting for DCFS to make certain orders or to review documents or make child support orders, and you have to wait months and months. And You have to deal with some of these social workers that actually refuse to speak to attorneys. I've tried to contact the social worker on my client's behalf, and they refuse to speak to me. They say, we don't talk to attorneys. We need to just speak to the client directly. And unfortunately, look, they always have the public's best interest in mind. That's the final goal.
That's
always.
the intent.
That's the intent. But
is it a safety net? Do they provide a safety net, an effective
sometimes,
safety net?
I mean, sometimes, but I think as in any government program, I'm sure there's holes in the system.
Raymond, speaking of holes in the system, what about holes in the condom where the condom gets thrown away and the man thinks it was thrown away, but then the woman goes in the trash can when he's sleeping, slips it on, it goes in, and she gets pregnant.
Wrongful impregnation as a tort, perhaps?
Is that even possible? I thought
it's documented.
That's a scientific thing that I'm not clear
what
on.
What I heard was that one guy found out about it and he faked being asleep. Then when she was asleep, he poured Tabasco sauce in the condom, and she had a nice little rash there for a week.
Huh. Okay.
That doesn't sound like a healthy relationship.
Yeah, that's not
that sounds like a relationship that's destined to fail.
Yeah, I think that, I mean, there's a lot of arguments there, but at the same time, I mean, the act of sex is going on, and you're assuming those.
You're assuming those.
You're assuming the risk of getting someone pregnant.
You should
and
watch where you spread your seed.
If you're going that, you need to. I mean, that's why. I mean, if you're going to use a condom, you flush it down the toilet. Don't leave it in the trash can. I guess that's the advice there.
I think that's
Very
the best
specific.
advice you've given the entire show. But unfortunately, we are out of time. Please, while we have a minute or two left, if you would like, give, please, your contact information, whatever you want, so the listeners can call you.
Sure. Again, my name is Raymond Hekmat of Hekmat Law and Mediation, and my phone number is 424-243-5628. I have offices in Beverly Hills and Century City. Website is hekmatfamilylaw.com, HEKMAT, familylaw.com, and look forward to seeing my clients.
I thank you very much for coming in and taking an hour of your valuable time. And hopefully next year we'll bring you in again. That is awesome. For my chief of staff, Dr. Michael Zyma, for family law attorney Raymond Hekmat, for my protege, attorney Robert Ozeron, Scott Walton of Uncle Studios is on the board, and all the good people back at WorkComp Central that continue to support and approve of this valuable project, including, but not limited to, Leaf File and Jake Paris. My name is Steve Appel. We'll see you again next week for another edition of WorkComp Matters.